Hello, everyone. I'm Vedant Bisht, Associate at Economic Laws Practice, and I'm joined today by Mr. Sujjain Talwar, who's the founder of Economic Laws Practice. And today we'll be diving into a discussion on directors and the law. And if you are an upcoming independent or non-executive director or thinking about joining a board, I think this conversation is for you. So welcome, sir.
Thank you, Vedant. Um, I am a co-founder along with many others. But let me start with a little uncomfortable proposition. Most directors don't get into trouble for what they do. They get into trouble for what they allow. Let's just go back in history. We've all grown up with Mahabharat, with Ramayana. You may remember Bhishma. What was he? He was silent when the dice was rolled, and he allowed the game to be played and lost the kingdom. He didn't throw the dice himself, but his presence and inaction allowed the injustice to proceed. Similarly, over the last decade, the Indian boardroom has changed. The Companies Act and an increasingly assertive SEBI have quietly redrawn the role of a director, not from a general advisor, but now to an accountable fiduciary. So, the question is, when things go wrong, the question regulators and courts normally ask is not, was this illegal? The sharper question that boardrooms and regulators ask is, where was the board? So,
I think
you
that's
may
a
well ask me, as to what
that's a
does
very
the law expect from you?
right, sir. I think the very basic introduction the listeners could get is what exactly does the law expect from the directors, and does it vary depending on their role?
It's a very good question, Vedant. Um, there is a popular misconception that if you're not in the day-to-day management, your exposure is limited. It sounds reasonable, but that's not how the law works. The law actually doesn't care whether you're executive or non-executive. Both under SEBI and under the Companies Act, the directors, whether independent or non-executive, owe the same core duties to these stakeholders. And what are they? They act in good faith, to exercise due care, skill, diligence, apply independent judgment, not simply endorse management's view, and protect minority shareholders, and now under 166, even other stakeholders like employees, creditors, and the environment. There is, however, most lawyers will tell you, there is a golden section which they quote, called section 149, subsection 12. And what it tries to do, it doesn't eradicate, it tries to limit directors' liability to acts that occurred with their knowledge and consent or where they did not act diligently. But read very, very carefully. That carve out is narrow. If something went through a board process, you were in the room and you did not ask the obvious questions, you are very much in the zone of liability. A useful way to think about it is you sign up for the whole movie, not just the scenes you personally directed. That's exactly what I think the law expects from you.
Thank you, sir. I think that was a very good description. But so it's just not misconduct that would lead you in trouble. Apart from obvious misconduct, how do directors usually find themselves in legal and regulatory trouble?
There are some very common occurrences, okay? The law today punishes not only misconduct, of course it punishes misconduct, but you never find that so easily. What it does is it punishes you for your inattention, and it dresses up that word as trust. The real risk is not dramatic. It's the quiet moments. And what do I mean by when I say the quiet moments? That related party transaction that was so-called within limits, it sailed through without probing the benchmarking. There was a whistleblower complaint that was noted but not really pursued. The board meeting where the papers were thin, the answers thinner, but yet the resolution was unanimous. Those are some of the failures that government is trying to address, whether you look at Satyam, whether you look at ILFS, whether you look at DHFL. In all those cases, the spotlight, where does it eventually turn? It turned to the board and its independent directors. The consistent question was, given the volume of red flags and the scale of this problem, how did this pass through any board process, audit committee without robust challenge or dissent? Even when you look at study some of SEBI's orders, and I'm not saying they're all right, they rarely accept something where your defense is, I relied on management as a complete defense. They don't accept that. They say, did you insist on information? Did you probe inconsistencies? Did you record your concerns? If the minutes show a pattern of mechanical approvals and no questions, that's a problem. Remember, in corporate law, unlike maybe in criminal law, silence is rarely neutral. If the minutes say a resolution was passed unanimously and you were present, you are deemed to have agreed unless your dissent is clearly recorded.
I think that's very insightful, sir. Uh, so we hear a lot of these words when we talk about directors, duties, liabilities, compliances. So for those of our listeners who may not be aware of the legal meaning of these words, could you explain what it means in plain English?
In simple English, I think you need to remember three words: duty, liability, and compliance. The last one, to me, being very important, behavior. So what is duty? Duty is what I told you, what the law expects you to do. Act in good faith, use care, independent judgment, safeguard the interests of the company, minority shareholders, etc., etc. What is the liability? Liability is what happens if you don't do your duty. Under the Companies Act and in some other cases and under other laws that may be relevant to that particular company and the sector in which it is operating, you can face penalties, disgorgement, and in the rarest of cases, imprisonment. But one thing that gets hit before a final order arrives is your reputation. Your reputation will almost certainly take a hit. When I come to the last, why did I say it's the most important? Because behavior is now how you close the gap between duty and liability in real life. It's how you read board papers, how you respond to discomfort, how you use all these committees, audit, stakeholders, NRC, and how you document what you did. What does this mean on a practical level, Vedant? You scrutinize related party transactions, ask for the underlying valuation, benchmarking, fairness opinions, and the alternatives. Every good company has this. And to my experience, they have already been through this process, but it's good for you to see it. Just good governance. Whenever you get a whistleblower complaints, don't take it lightly. Cyber incidents, regulatory notices, don't treat them just as operational irritants. They are board level risk issues. There is a risk register. Pay attention to that and see how you address it. And lastly, I think this is becoming more and more important, is test the financial controls and risk management systems. They're not just to be noted. Test them. Time and again, test them. And that's when you'll find that either you are on a good wicket or you need something that needs fixing.
That's some very good and strong advices, sir. So if you had to sum up all these findings and give up 5 practical habits that a director should build to both protect themselves and also to genuinely add value to the board, what would those be, sir?
See, somebody will always approach you. It is very rare that a director goes to a company and say, please make me a director. I think that's not the right way to do things. When you are approached, do your diligence. You read the annual reports, see if there are auditor qualifications, related party disclosures, any major litigations. If you don't feel that there is enough transparency, it's not going to get better when you join. So be careful of that. Fix the basics. Ensure the law has tried it, but you must ensure that you have complete information in a timely manner. You can't expect to read 150 pages 3 days before the board meeting and understand everything. And I would say use AI to the extent it gives you the privacy and the ability of speed. Use minutes as your shield. Why do I say as your shield? Because if you ask hard questions, if you gave only conditional approval, if you dissented, make sure it's accurately minuted. There's no harm in dissenting. There's no harm in asking the hard questions. In fact, most good promoters expect you to bring that value to a board meeting. They want you to ask the tough questions, which they may have ignored, or they may have a CEO, and the relationship between someone who's there full time versus you coming 4, 5, 6 times a year is slightly different. You can afford to have that hard question and answer session. Treat your DNO policy insurance, don't treat it as a footnote. Use it. It's a lifeline. People have been scarred. Look at all those independent directors who have lost a lot of their reputation, paid huge fees, incurred huge expenses, only to get their name cleared. If they had a good DNO insurance policy, maybe this would have been less of a headache. So check that policy. And my practical advice is run it between 2 or 3 other insurance brokers so that they tell you exactly what's not covered. Because what's not covered becomes the important bit that you need to try and bridge. And sometimes your duty is to say, no, this cannot go through on this basis. Go back, redo it, and come back to me after all these questions are answered, and we'll re-look at it. We're not saying no. So have that confidence and record those reasons. And I suppose the one question that you have to ask, which is more of conditioning and it comes with experience. You are not out there to become obstructive. You are there to be effective. You have to be supportive to what the company is doing, but not just compliant, not taken for granted. And you have to be independent, but not irrelevant. So coming back to our story of mythology of Mahabharata, Ramayana, try and be the Krishna who's advising Arjuna. Try and be that kind of advisor. If there's one thing I would take away from this episode till we wait to the next, is that the law will judge you not only by what you knew, but by what you should have known, but chose not to ask about. Your greatest asset in the boardroom is not your CV or your network or your net worth or your past title. Many have that. It is your willingness to pause a meeting and ask an uncomfortable question and to have that question properly recorded and answered. If you're prepared to invest that time, promoters will love you for that. Put your reputation on the line and be both coach and whistle when needed, then being a director can be one of the most meaningful roles of your professional life. Thank you for listening. And Vedant, to all our listeners, viewers, whoever they are, stay curious, stay diligent, and we'll see you in the next episode.